Hi there, students. In furtherance to the previous lecture that we had online on comparative animal welfare laws, we move forward towards specific animal welfare law of United States of America. Now, we started with the Animal Welfare Act and its subsequent amendments in the previous video lecture, if you have followed it. Now, moving on to the crucial elements of the Animal Welfare Act of 1966. In today's lecture, I would like to highlight some of the key features, some relevant provisions which is related to certain authorities, identification of stakeholders, and of course some important case laws. Now, when it comes to United States of America, the Animal Welfare Act of 1966 is a federal legislation, as I have already discussed. This legislation, in fact, way back in 1966, when it was enacted by the then President Lyndon Johnson, and this is a main federal law for the United States, which basically regulates the treatment of animals in research areas as well as in exhibitions. Other laws, policies, and guidelines may also include as an additional species coverage or specifications for animal care and use under this particular legislation. But there are certain minimum acceptable standards which have been prescribed by this particular legislation. There are two agencies which are pretty much federal agencies which are pretty much responsible for the same. Here I would like to stand correct because in previous lecture, by mistake, I have referred USDA as drug agency, but I was wrong about it. It was United States Department of Agriculture. I just confused it. So the United States Department of Agriculture and Animal and Plant Health Inspection Service, also known as USDA and AMPHIS respectively. These are the two agencies, federal agencies, which is responsible for overseeing the Animal Welfare Act. And at the same point of time, there are certain committees which has certain primary jurisdiction over this act. These committees, also known as, say, for example, House and Senate Agriculture Committee, which are primarily responsible, which has certain legislative jurisdiction over this act, they are also responsible for the implementation of this particular legislation. Now, animals that are covered under this act includes not only live animals but also dead animals like cats, dogs, hamsters, non-human primates, rabbit, guinea pig, and several other warm-blooded animals, which may be determined by the Secretary of Agriculture for research purpose, pet use, or even for exhibition. However, there are certain species which are excluded from this act. These are, of course, the bats. Sorry, not the bats, but the birds. The rats, and the laboratory rats. Then you have these mice, which also commonly known as the lab mice, which is of genus Mus. Farm animals and cold-blooded animals. So basically, the birds, the rats, the lab rats, the lab mice, the farm animals, and the cold-blooded animals. These are excluded from the Animal Welfare Act. Now, in addition to that, I would like to mention a bit about this USDA and AMPHIS here. The United States Department of Agriculture, also known as the Agriculture Department, is a U.S. federal executive department, and this agency is basically responsible for development and execution of several federal laws relating to farming, then rural economy, forestry, and food. In fact, it aims to meet the needs of the ranchers, the farmers. It also promote agricultural trade, production. It works for ensuring food safety. It protects natural resources, fosters rural communities, works for ending the hunger in United States and also internationally. And this particular organization is quite responsible for several components because they also deal with agricultural buildings and facilities. They also deal with hazardous materials management. These are some of the areas which also comes under their avenue. However, in addition to that, if you refer to some other legislation where you will find USDA plays a very significant role in the United States, include the Meat Inspection Act of 1890. Then they have this Pure Food and Drug Act of 1906. They have the Federal Farm Loan Act of 1916. They have Food Control and Production Act of 1917. They have something called Packers and Stockyards Act of 1921. They have a Agricultural Credits Act of 1923. They also have Perishable Agricultural Commodities Act 1930, Soil Conservation and Domestic Allotment Act, so on and so forth. There are n number of such legislations. Even after 1972, they came up with several legislation. They have this Nutrition National School Lunch Act. They have the Safe Drinking Water Act. They have the Food and Agricultural Act from 74 and 77 respectively. They have the Food Security Act of 1985. They have also Agricultural Risk Protection Act of 2000. In 2010, in fact, they came up with this Healthy Hunger Free Kids of 2010 Act. So all these legislations, there are more than 30 such legislations where you will find that USDA is responsible for its implementation and overseeing. Now, in addition to that, the Animal and Plant Health Inspection Service is something which, it's also a federal agency of the same Department of Agriculture. And you can find them that they are based in Maryland, and they're responsible for basically for protecting the animal health, for animal welfare at large, and of course, plant health is also included within the paradigm of within the ambit of AMPHIS. It's a lead agency, in fact, which is also responsible for collaboration with other agencies to protect the agriculture from, say, invasive pests and diseases. They also have, in fact, that is the reason since they also cover plant health. AMPHIS is also regarded as, sorry, not Amphis, APHIS. M is not there. It's APHIS. APHIS is also a national plant protection authority for the United States. And they have certain duties under the legislations. And thing is that the AMPHIS, in fact, as I mentioned, it aims to protect the animals, the American animals and plants, and the agriculture industry. And they do that by offering protection from, as I mentioned a while back, invasive non-native plants, animals, insect diseases. They also monitor and manage existing agricultural pests and diseases. They also, adopt certain resolutions with respect to management of trade issues relating to animal and plant health. And they are also responsible for prevention and cessation of any inhuman treatment of animals. So the AFIS is something which is quite, in fact, they deal with several areas, and within the scope of AFIS, you will find biotech is coming, invasive species is coming, agricultural animals, plant health threats, agricultural bioterrorism, sanitary, phytosanitary trade barriers, wildlife conflicts, zoonotic diseases, animal welfare issues, etc., etc. And for that, you should also refer to certain statutory authorities from where it is, the FS is granted that specific authority under several federal statutes, not just one. Animal Welfare Act is just one. In addition to that, Animal Welfare Act of 1966, you have Animal Health Protection Act, which also grants special authority to AFIS. You have the Horse Protection Act, then you have Animal Damage Control Act of 1931, Lacey Act, which is very important legislation because it makes it unlawful for any person to import, export, transport, sell, receive, acquire, purchase, wildlife, fish, anything like that. This is a wildlife law of America, the Lacey's Act, because it covers not just internal but also internal, external, because it deals with the export of and transport of certain wildlife, animals, plants, fish, etc., etc. So Lacey Act is also grants certain authority to AFIS. Then you have Plant Protection Act. Then you have Federal Seed Act, Honeybee Act. They have a legislation for honeybees because it is an industry, as you all know. They have animal quarantine laws also in their country, and they also have something called Virus Serum Toxin Act. And APHIS has been granted authorities under all these legislations. When it comes to Animal Welfare Act, it in fact required all the animal deal to be registered and licensed under this particular legislation. And as I mentioned, this legislation, in fact, has a licensing and registration mechanism within it, which requires all the business that either sell or buy warm-blooded animals, because cold-blooded animals are not included, but warm-blooded animals. And if you want to exhibit them to any public, area, or if you want to transport them commercially or use them for teaching and experiments, well, you have to get yourself licensed and registered. And if you fail to do so, then it's a punishable violence of Animal Welfare Act. And depending on the business in which you are dealing with, the AFIS, the Animal and Plant Health Inspection Service, as I mentioned a while back, determines whether the business should be licensed, registered, or both. And business owners are responsible to know about the licensing and the registration requirements. Several business activities which are also covered under that, and these are the major stakeholders. Animal dealers are there, exhibitors are there, and you also have transporters. Now, in addition to that, you should also know that after subsequent amendments, the Animal Welfare Act, in fact, it referred to the specialized committees. The After 1985 amendment, all the research facilities covered by this Animal Welfare Act has required to establish a specialized committee, which include at least one person trained as a veterinarian, and at the same point of time, one not affiliated with the facility. So these committees regularly assess animal care, treatment practices during the research. It's also required to inspect all other animal study areas at least once in every 6 months. In fact, these committees are also required to ensure that alternatives to animal use in experimentations would be also used whenever it's possible. If it's not possible, then you have to go ahead with that. So that is the role of the specialized committee under the Animal Welfare Act, and this came after the amendment of 1985. Coming back to the businesses and activities which are covered, as I mentioned, animal dealers, exhibitors, and transporters. When it comes to animal dealers, these are the people who usually sell animals bred to their facilities, right? Like pet and laboratory animal breeders, brokers, auction operators, etc., etc. So they must be licensed as per the Animal Welfare Act. There are certain classes. There is a Class A and Class B license. Class A license are given to those breeders who basically deal only in animal that they bred and raise. However, Class B license are granted to those people who buy and sell animals and they do not raise. So those who raise, they have to go ahead with Class A license, and those who just bought it to sell it, they are supposed to get the Class B license. And the annual license fee is also charged, which ranges from somewhere around $30 to $750, depending upon that particular business that they are dealing with. The next is the exhibitors. The exhibitors are also, of course, is a business where a person who displays the animals to public. Exhibitors must be licensed under this Animal Welfare Act, and they will be licensed by FS itself. And for them, they will get Class C license. Class C license, usually the exhibitors, which includes under like zoos, for example, educational institutions, marine mammal shows. Then you have these carnivals also in the United States. So however, the laws and the regulations exempt the agricultural shows like horse, then pets shows, game preserves, hunting events. These are excluded. But besides that, the annual license fee, which is of course around somewhere around $30 to $300, is required to get this license C and Class C, and this Class C is granted to those exhibitors. Next comes the transporters. The transporters are basically those individuals who are in the commercial business that usually involves movement of animals from one location to another location, and it is considered as a transporter under the Animal Welfare Act. Now, these animal transporters also must be registered, including, say, general carriers, for example, the trucks and the trucking companies, airlines, railroads. So they too also have to get themselves registered and licensed for the same. And finally, you have, which I haven't mentioned in here, the research facilities. The research facilities are also covered under the AWA. These are those facilities which are engaged in use of animals for experimentation, surgery, testing services, and all. And they must be registered. They don't have to get licensed, but they must be registered. And these include the state and local government-run research laboratories, also universities, colleges, etc., etc. They must be registered for the same. So the transporters and the research facilities, they should be registered, while animal dealers, animal dealers and exhibitors, they will get license Class A, Class B for animal dealers, and then comes for exhibitors Class C. Now, AFIS also has this animal care program, which in fact oversees the Animal Welfare Act, and they have around 10,000 facilities across the United States, and they usually make unannounced visits to several such institutions, which are of course from several sectors who are dealing with the animals, and they usually they have this unannounced facilities inspections, and which kind of is done to ensure that they are in compliance with the regulations. And AFIS do that and goes to all these regulated 10,000 odd facilities. And under the Animal Welfare Act, also these facilities are to be inspected at least once every year, with the follow-up inspections usually conducted under any deficiencies. If they have identified well, to check that they have corrected the deficiencies, they can also visit again. So investigation and inspection is something which is also there under the same. And if someone violates the Animal Welfare Act, then the Secretary of Agriculture has, if they have any reason to believe or even suspect that the licensed dealer, the carrier, or operator, whoever it is, exhibitor, has violated any provision of AWA, then their license will be suspended temporarily, but not to exceed 21 days until a hearing is held. So after the hearing, the license may be revoked, or if the violation is determined to have occurred. So the dealer, carrier, exhibitor, handler, operator, research facility, whoever violates any provision of Animal Welfare Act may be assessed a penalty of no more than $10,000 for each violation. And any person who knowingly fails to obey an order made by the Secretary of Agriculture is subject to a civil penalty of $1,500 for an offense. However, you should also keep in mind that any dealer, exhibitor, courier, handler, auction, operator, research facility, they may also seek a review of the order within 60 days. That's the limitation period. Within 60 days at the United States Court of Appeals. This is what it is. With respect to that, I would also like you guys to refer to this HBO documentary from the year 2006. The name of that documentary was Dealing Dogs. Please refer to that. That was an undercover operation which was done to target the Class B kennel, which treated dogs inhumanly, violating the Animal Welfare Act. Please do refer to that particular legislation. Sorry, documentary. Now, there are certain case laws which I would like you guys to refer to. Basically, these three case laws come here when I searched, and one is, of course, the International Primate Protection League versus Institute of Behavioral Research. Then comes the Animal Legal Defense Fund versus Glickman, and then the Whitehead Streets Incorporation versus United States Secretary of Agriculture. The first case, International Primate Protection League versus Institute of Behavioral Research. Now, what happened is that in this case, in 1981, a graduate student, and he was also there as along with a PETA member. A graduate student who was also a PETA member. His name was Alex Pacheco. So he volunteered a research in Silver Spring, Maryland. If you remember, I think in the previous lecture I have mentioned about it. And what happened is that at that time he was conducting this research, and there's this guy called Edward Top. He was conducting a research on monkeys for neuroplasticity purposes at that particular center in Maryland called Silver Spring. Now, while Alex spent time in the research center, he noticed that there was certain inhuman treatment of monkeys which were done under the Animal Welfare Act, and he reported it to the police. Then he filed a suit against Edward Top, who was researching that. Afferent ganglia. So Edward Tubb was convicted for six animal cruelty charges, which were also appealed in the second trial, but they proved to be significant in understanding of the law. So this case, in fact, provided an advancement in neurology research, but it was doing so only by risking the inhuman treatment of animals. And this is what the court identified. Another case was there from 1998. That's the Animal Legal Defense Fund versus Glickman. In this case, what happened is that in 1998, a court case was argued on behalf of this Animal Legal Defense Fund. Now, what happened is that this was for inhuman treatment of a primate named Barney, and Barney was in Long Island Game Farm Park and Zoo. And this man named Mark Jornob, he had visited this park on a regular basis, and he noticed that this primate had been neglected, and he filed a suit with USDA for failing to meet the minimum standards under the AWA. And this allegation was also supported by investigation which was done, and finally, the United States Court of Appeals and even the DC's, the District of Columbia Circuit Court also ruled that he was standing to sue, and the merit of the case was determined by a later case, which is from 2001, where the court rejected Junovi's argument and upheld the validity of USDA regulation. And then comes the 907 Whitehead Street Incorporation versus United States Secretary of Agriculture. This is from 2012. This is a case where the plaintiff challenged the jurisdiction of USDA, and also he challenged the FSS jurisdiction to regulate the Ernest Hemingway home and the museum as an animal exhibitor, because the museum was a home of dozens of such cats, and the progeny of cats that was also there, and that was something which was of great significance. So USDA visited this museum for inspection, etc., etc., and it somehow went there. The museum, in fact, challenged on several grounds that USDA's authority in the case, noting that Ernest Hemingway's cat do not have an effect on interstate commerce sufficient to merit the federal regulation. But in December 2012, the case has reached the United States Court of Appeals in the 11th Circuit, which in fact upheld the earlier district rulings, which clearly say that the USDA regulation, the museum is required to obtain a USDA exhibitor license, given each cat a tag for identification purpose, provide additional resting surfaces for their existing enclosures, and also to introduce one of the several specific improvements required to ensure that the cat remain contained in the museum's ground. So these are some of the case laws where we have seen United States, in fact, went to the extent of giving directions to the authorities as well as the individuals who have violated several provisions of Animal Welfare Act. So in a way, I would say that in conclusion, the Animal Welfare of United States is a very progressive legislation in comparison to what we have in our country. Please do refer to the Animal Welfare Act of 1966 and all those amendments that I have already discussed, and you will also come across several other case laws in addition to those case laws that I have mentioned over here. So, in the next class, I'll refer to other facets of comparative environmental law. Until then, stay safe, stay home, take care of yourself. Thank you very much.